Well, it's 6 o'clock, so I know we'll let other people in as they log in, but we want to be a little timely. So we'll go ahead and get started. So I just want to say good evening, everyone, and thank you for joining us for another edition of Family Matters with Judge Smith, Judge Phil Smith. We are excited to do this on a consistent basis to keep people updated and informed about various family law matters as well as updates in our courtroom. And so we love doing this. We enjoy having everybody come and participate. We see some familiar names. I'm not going to say faces. I don't see faces, but I see names for sure. And so it's really nice to have you guys tune in and to support this effort as we continue to educate the community at large and inform attorneys in our courtrooms and in the area of family law about different things going on in this area. So first, I want to just kind of get caught up, Judge Smith, with you to kind of see what have you been up to this summer?
Well, as little work as possible, but no, actually, after the election in early May, things kind of started to die down a little bit. Fortunately for me, right now, I have nothing under advisement. That may change week after next, but nothing under advisement, which is a great feeling. Had a great Father's Day.
Yay.
Went out on the lake with one of my daughters and my wife. Beautiful day. Spent a lot of time. We were on the boat. I got to spend a few days on the boat. It was missing me. So I had to give it some attention. And it's just been a really, really enjoyable couple of months for me. Kind of getting away from the campaign, getting things fairly caught up. As far as the caseload is concerned, we're still, probably 6 to 8 months, maybe longer, in getting caught up to where we were prior to COVID. We're going to be having a look at the caseloads for all of the state trial courts over the next few weeks, maybe with the exception of criminal court. I'm not sure we're going to have the data there to be able to do it, but kind of see if any adjustments need to be made where everybody is going into the new term. We've got some new judges coming on, and unfortunately, we've had some friends that didn't get reelected. It's always tough, but for me personally, it's been a good couple of months, and trying to enjoy it as much as I can. Hot weather.
Oh, it's hot.
Oh my gosh, it is just good old Middle Tennessee humidity.
Yes, it is so hot.
It really, really is. In fact, this morning was a little warm in the courtroom, but we got it cooled down. So anyway, what's going on with you, Steph? Let's bring everybody up to speed with you.
Well, so let's see. I don't know if people on here know this or not, but for now, I'm kind of handling adoptions. And I have been enjoying that. It's an area in the family law arena that I have not had a lot of personal exposure to. I did not do adoptions in my practice when I was practicing. And of course, we know Brenda Parks was our adoption queen. And so I've learned a lot and I'm continuing to learn. I'm enjoying working those cases and servicing our attorneys in that area as well as their litigants. So if you all have adoption questions or have an adoption coming through the pipeline in Fourth Circuit, give me a call. I'm happy to chat with you and answer questions and find out answers to questions I do not know. I will say a huge resource to me has been Kopic on adoptions. Don Kopic, I think, is the author of that. But it is so helpful in understanding different things relevant to adoptions. They have good forms in there that really cover the basis in terms of what the statute requires for a petition or a termination order or a final order of adoption. And so if there are attorneys here that practice in that area or that are looking to practice in that area or just pick up a couple of adoptions, that would be, in my mind, a very invaluable resource to you to make sure your paperwork is right on the front end. Because what we're finding is when people are filing their motions to set or motions for default, and I go back and look at the file to see, make sure everything is in the paperwork like it needs to be, there are quite a bit of things that we have to get straightened out before we're able to move forward. So in any event, your adoption questions certainly come to me for now. Other than that, I've just been busying myself with life in general, I guess. I will say something really cool I got to do last week. I don't know if people are familiar with the synchronous fireflies that are in Gatlinburg or the Smokies every year for about a 2-week period or so. But I got to go see that last Friday along with a bear. And it was a lot of fun. It was really, really, really cool. It's something to see. It's a once in a lifetime experience and kind of thing. And it was really cool. So yeah, that's about it.
It is now officially on my bucket list. I've already talked to both my daughters, and we want to take the whole family up there next year and get on the list. And maybe we can do without the bear, but the fireflies are something we want to see.
Yeah, it's probably not a good idea to be eating snacks out in the open in the Smokies, and because they're looking for food, the bears are, and they will show up looking for food. But I thought I'd be really afraid, and I was. I mean, I was kind of like frozen, quite frankly. I just kind of froze. But that bear encounter was not threatening at all. They're very quiet, kind of like cats. You don't really hear them coming up on you. And then as soon as he heard this, like my feet moved and kind of there was gravel under my feet. And so it kind of made a noise from that. And he ran off really fast. So I don't think they're really there to try to attack anybody, but they will show up looking for food. So anyhow, so there you have it. So do we have any announcements from Fourth Circuit Court that we want to share with anybody?
Well, we've got Andrea who passed the bar, and we've got somebody that will be joining us in September to replace Brenda. And I guess it's okay to mention it. Do you think, Steph?
I think it is. I think we've got the green light to do that.
All right. Well, I am bringing Ronelle Griffin on to replace Brenda. Most of y'all know her as being with Judge Solomon when she was on the bench, and with Judge Jones for the past 8 years. Ronelle has been a good friend to many of us for years, and it's funny when Brenda Parks was in my office talking to me and Stephanie, and right after she had announced she was leaving, we said, let's think about who we could approach to replace you. And Brenda had one name, and Stephanie and I both had it in our mind, and that was Ronelle. So we're really looking forward to having Ronelle. She's part of our family. We love her, and can't wait until September, early September when she starts.
Absolutely. So yay. Okay, so tonight's topic, new developments in family law. This was something that you were really interested in pursuing tonight as a conversation. So why did this come to mind for you? What was it that you were thinking about, and what are some things that you want to touch on tonight as it relates to developments in our law?
Well, I was really kind of thinking that the Roe decision out of the United States Supreme Court would have come down by now. I wanted to kind of touch on it. It's not really, assuming that it goes the way of the leaked draft opinion, it's not really going to affect divorce so much as it will affect adoptions and surrogacy. Those things are where it will have the most impact. I was hoping we could discuss some of those things. but I don't want to discuss them until we know for sure that, Roe is going to go the way of the draft opinion. I'm still hoping for a compromise, but we'll just have to see on that. So what we're going to talk about is just new developments, mainly in the divorce area, and some new statutes that are going into effect, and just things that are going to help lawyers, their day-to-day practice of divorce cases, handling divorce cases.
And I do want to let people know that if at any time you have a question, feel free to put it in the chat box. We have a crowd tonight, the size of everybody viewing is such that it could be very manageable if we might just open it up for you guys to turn on your video so we can see your faces and ask some questions. But I want to go through a few questions that came in advance of this evening first. And one was something we were talking about right before we logged on to this, Judge Smith, as it relates to this new law that is coming into play as it relates to the new factor in custody cases relevant to a parent paying child support for 3 years. Let's talk a little bit about that.
Yeah, that was kind of a surprise in seeing that come up. Technically, we have never really tied the non-payment of support to visitation in any sort of formal way. Now, Tennessee Code Annotated 366106A16, I think is the subsection, says that we have to consider the non-payment of support that has not been paid for 3 years. Do I think it's going to have a tremendous effect? I don't think it will when we're actually talking about the primary residential parent status. It's I'm not talking about the schedule. I'm talking about the primary residential parent status or on modifications. And if you think about it, a parent who has not paid support for a year, 2 years, 3 years, 10 years is not really going to be, unless they have a great excuse, is really not going to be considered realistically for a primary residential status. And I say that because if they haven't paid support, in all likelihood, they probably haven't visited. They probably have not established that relationship that a primary residential parent would generally have with the child, things of that nature. And if they haven't paid child support, you've got to get into why they have not. Was it a willful non-payment of support? Were they just kind of giving the court the finger and not paying the support, trying to punish the other parent by the non-payment of support? A lot of different things. I really don't think it's going to come into play that way when we're talking about primary residential status. Those are things that we haven't traditionally been required to consider, but yet we do consider that. I mean, if you can't pay your child support, on a reasonably regular basis, then how can you really afford to raise your child, be the primary residential parent to raise your child? So I don't think it's going to have an effect there. I do think it could have an effect on the schedule, which is part and parcel of the parenting plan. I do think that if you've got a parent who has not paid for 3 years, they don't have a reasonable basis for not paying. then I think, you know, you do have to look at it hard. Should this parent be out working, spending less time with the child so that they can pay their child support? I do think from a visitation schedule standpoint, it could really have a pretty heavy effect, particularly on maximizing time.
Mm.
You know, if you're not paying your child support regularly, how does the court justify maximizing your time other than what's, you know, looking at the best interest of the child? And there may be cases where excuse me, there is an excuse, there is a justifiable reason why it has not been paid, but you know, that's a court order, and you know, your failure to comply with a court order goes to your judgment, and that's something we always have to consider. So,
And so now when you reference the court order as part of this, and I apologize, I don't have the language of it in front of me. Let's say that there has not been a court order for support. Would that factor come into play? Let's say the child is 9 and a parent has never paid support, but there has never been a court order. There's never been court intervention. How would that factor come into play, if at all?
you know, I have to say, I mean, there are a lot of sub factors in that. Does the non-custodial or alternate residential parent know that they had an obligation to pay? Was the child sequestered from them, you know, as far as, you know, being hidden? There's a lot of different factors you have to look at that. I do think if there's no court order, then you have to look at it a different way than if there is a court order. So again, you know, if there is a court order, I think you probably look at, well, is this in fact a willful non-payment? If there's no court order, you got to look at, you know, knowledge of the obligation, you know, where have the parents been? Was there a private agreement? Was the child sequestered? All of these different things come into play in that situation.
What are you seeing in terms of trends with alimony, if at all? You know, alimony is always everywhere and nowhere at the same time. What are you seeing as it relates to any trends in alimony?
You know, I guess what I'm seeing is, and these are mainly from appellate court decisions, you know, there are all these factors that we have to consider, but yet need and ability to pay are the two primary factors, according to the case law. And I understand that, but with these other factors, do they mean nothing? You know, standard of living, tax consequences, all of these other factors seem to really have no bearing or very little bearing as far as the appellate courts are concerned, need and ability to pay. And, you know, that's not really a trend. That's just a continuation of what I've seen out of the appellate courts for really most of my career.
Now, it was interesting. We had a conversation a few months ago where you had a case, and a big factor for you, or a factor that you were honing in a little bit more on from the alimony statute, that we don't always get to look at so closely, is the standard of living. And I think we had a conversation about, you know, when there is, you know, a lot of times we don't see the incomes that would support necessarily, you know, keeping a disadvantaged spouse at a similar standard of living as the obligor spouse. But there are cases that I guess that would become a bigger factor than need and ability to pay. You want to talk about that a little bit?
Yeah, it's you know, in a lot of I mean, we, you know, we deal in the real world in the trial courts, not bashing the Court of Appeals, but we deal in the real world. And a lot of times, because of a limited or a lack of a substantial income, then standard of living has to give way to the ability to pay. Okay, you can't really get to standard of living because there is a limited ability to pay. But yet, when you have a high-end wage earner, making $1 million a year, then you can consider standard of living and go beyond need and ability to pay to that standard of living. It doesn't have to give way to the ability to pay. The ability to pay a substantial sum is there. And I guess what my question is, maybe some of you folks can answer it, is, the legislature is active. Whether we agree with what they have done or not, they require us to consider all of those factors. Is just considering need and ability to pay, is that thwarting the will of the General Assembly? And, I don't know. We've had so many years of, the focus on need and ability to pay that it seems to me that we're kind of beginning to substitute our own judgment as judges for the written statutory, the black letter statutory law. So I wish and I hope in the future that we do get back to that. Let's consider all of these factors that we're required to look at and make findings of facts and conclusions of law. Defer to the discretion of the trial judges more, unless we abuse that discretion.
So now we do have a statute that I guess more so codifies the definition of marital debt.
Yeah.
You want to talk about that a little bit?
Well, basically, and that was Judge Martin's statute. Judge Jim Martin was driving force in getting that statute through, which is a good statute. It was always kind of really strange to me that, when your division of property, the provisions dealing with division of property, which found at Tennessee Code Annotated 36-4-121, never mentioned debt, but it talks about dividing assets. And, for all of these years up until the effective date of that statute, we had common law guidance, case law directing us on how to divide debt, what to consider, things of that nature. And the statute is generally a codification of that common law. But I think it's good to have it all under a statute, have it as part of the statute now. And, statutory guidance on how to divide that debt, considering who, what it was incurred for, who incurred it. I think it was a good move on Judge Martin's part to make that part of the statute.
Let's talk a little bit about domestic violence. Are you aware of any new statutes that are coming out that address domestic violence? And do you want to talk a little bit about something that is now available to victims of domestic violence forms that they are able to use to get back into court when someone has not turned in a firearm?
Yeah, I don't really believe anything. I don't recall anything coming out big this year. But we have put together a procedure in Davison County to deal with the non-filing of the firearms dispossession provisions. And if the testimony reflects during an order protection hearing that a firearm is owned by the perpetrator, then they're required to execute a firearms dispossession affidavit. In other words, the affidavit requires them to set forth where the firearms have been disposed, that they have been disposed of, placed with someone else that they don't have access to, things of that nature. Now, what we have done is we have gone to we put together a procedure that allows a follow-up to ensure that that affidavit is eventually filed with the circuit court clerk. And what it does is it just provides a motion that's on the clerk's website. You have to list the docket number, the style of the case, and I believe the date of the proceeding, and that an affidavit was required to be filed, and it hasn't been filed. And at that point, what Judge Robinson and I do, we will take the order, which is essentially a show cause order or order to appear. We'll fill in a date and we'll put that on our show cause docket, our Thursday docket, for folks to come in and explain why they have not turned in that firearms affidavit, disposition affidavit. And I've got 2 of those on Thursday, actually, first 2 that we've had. We've had this in place for a while, but it's the first 2. And I believe that on one of those, I was told by one of the staff today that they have turned in the firearms affidavit. So we've accomplished what we want to accomplish by having that affidavit turned in. Now, we have an issue of court cost. And it is my thought and Judge Robinson's thought that if we have to file this show cause order, this order to appear, for them to show cause, why they didn't turn in the affidavit, then they ought to be responsible for the court costs. So we're going to be dealing with that on Thursday. And that is our procedure to make sure that the firearms affidavits are turned in. Now, with that said, it is incumbent upon the victim or the petitioner, whatever term you want to use, to check and see if that affidavit has been turned in and make sure that that person was required to turn it in, and up to them to file the motion. There is no charge on the motion, and all of the court costs will be taxed on the back end. So we're making it easy for the victim, but they will be required to come to court, and there's good reasons for that. An individual could say, "Yeah, I turned my shotgun over to my uncle who is keeping it and won't allow me access to it, and so I've complied." Well, if the victim's there, well, what about his 45 Colt semi-automatic handgun? What about his AR-15? All of these other things. So it's incumbent that the victim show up, and it's going to be, unfortunately, an additional time that the victim is going to have to be in presence of the perpetrator of the abuse. But we can only go so far in what we can do. We can't. Judges are an unbiased, should be an unbiased arbiter of the proof. And if it looks like we are going out looking for these things, we overstep our role as judges.
And so the forms are readily accessible on the
They're on Mr. Rooker's website.
Under the form section. So people are able to use that. Pro se litigants can use them, as well as attorneys if they are working with a litigant.
This process does not require an attorney.
A question that we received in advance of tonight is something we hear a lot, questions we hear a lot. And this question is the court going to start having some motions heard via Zoom? And or motion hearing dates and times that are Zoom? Or are we going back to in person? Well, we are back in person.
We are back in person.
People, we do get a lot of questions about, can I do this by Zoom or can I call in for this? Have X, Y, and Z going on. Can you talk a little bit about what our policy is at this point as it relates to remote hearings?
Yeah, I mean, we're back. We're back in person now. We don't know what the future is going to hold. That may change in the future, but right now we're back. And it's lawyers will call in and say, hey, I've got to be in another court. Can I do mine by Zoom? That's really not fair to the attorneys and the litigants that are coming in. Now, are there situations where we will use it? And the answer is yes, of course, we will use Zoom for very limited circumstances. I had a motion recently to be heard by Zoom because the litigant was in another state and it was an uncontested divorce. And I suggested to the lawyer, just let it go off on interrogatories. Zoom is a very difficult burden for us, particularly on the motion docket. One, you're going to be last on the docket, but two, it takes time to get people on. You're going to be waiting in the conference room for most of the call of the docket and getting through the docket. It's going to be an added expense to your client. And, Zoom is a great tool and was a great tool for COVID, but nothing supplants the court's observation of litigants when a litigant or a witness is sitting in that witness box. And credibility is such a key in what we do. It is very difficult to make credibility determinations via Zoom. Y'all are looking at me right now, but you don't know what's on the other side of my computer. It could be somebody holding up note cards. It could be somebody directing them and what to say. It could be, head shakes, head nods on helping them answer. So there's nothing at all like having a witness or a litigant in the witness box. It's really difficult to make an accurate determination of credibility on Zoom.
We have another question about relocation do's and don'ts. So do you mind sharing a little bit about your thoughts as it relates to relocation cases in general? Any new things that you see that are kind of happening with these cases, or anything that we're seeing any more than usual?
Yeah, the current relocation statute, which is found at 36.6108, is a very poorly drafted statute. Before this statute, we had two different categories of cases where there was not substantially equal intervals of time that the alternate residential parent had with a child or children. We had those considerations, the three considerations that we went through, and if they couldn't be established, then the primary residential parent could move. Then you had the substantially equal intervals of time, which was a more in-depth view of the relationship between the two parents and the child. And, you couldn't really predict early on as a lawyer how those cases would end up. At the same time, the statute provided great guidance. The new statute, again, is very poorly drafted. Parts of it are inconsistent. And it achieves its goal, which makes it very difficult for a primary residential parent to move if the alternate residential parent has a solid relationship with the child. And I think sometimes lawyers, when they're giving advice on the statute, they don't look at the statute before they give that advice. But it is a very tough situation when you've got a parent that is involved in the child's life. And it doesn't have to be substantially equal intervals of time. It can be far less as long as it is a solid relationship. So I would caution lawyers, please look at the statute. When you have somebody that comes in to interview you about a relocation case, take a look at the statute, look at the cases, although there's not a lot of case law under this relocation statute. Not a lot of cases have been tried. And remember that attorney's fees will probably be awarded to the other side if you ask to relocate and are unable to relocate. So attorney's fees and domestic practice is being really kind of attorney fee driven right now. So remember to advise your client, you could be on the hook for your former spouse's attorney's fees, which is something that a lot of people, get to the end of the case and, they're shocked that they're having to pay the other side's attorney's fees, which, is hourly rates are up. Cases are more complicated under statutes. And so attorney's fees are growing. And just, always be mindful of all of that when you're advising, particularly on a relocation petition.
And, we had a statute that I guess was really added. Maybe it's been about, I lose track of time, maybe 3 or 4 years now, where attorney's fees can be given in criminal contempt cases, change of custody or modification of parenting time cases. And so used to be kind of child support, and the enforcement of child support was there, but these other things that dealt with parenting time or custody or contempts was not. And so we are seeing or having to emphasize a lot more to people as they're bringing these petitions to be mindful about their clients' exposure to attorney's fees, in particular the petitioners that may not be successful on their claims. And I think you have recently had a case, maybe an alimony modification or so, where you've had to really take that into consideration.
Yeah, and that's that's something that certain categories of cases it's kind of always been there, but the new statute, which was really Judge Robinson's kind of his pet project a few years ago, and he worked with the Tennessee Coalition Against Domestic Violence and Sex Trafficking. He really worked with them on getting the statute through, and I was involved a little bit, but that was his project. And now I do, still kind of have that concern, and he and I talk about it every now and then. Is it appropriate to award attorney's fees in criminal contempt petitions? And the one argument is, well, wait a minute, if you're having to come in and enforce something that the other side was required to do by criminal contempt, shouldn't the person seeking the enforcement be made whole? That's a pretty strong argument. And I agree with that 100% as it relates to civil contempt. But criminal contempt, for all intents and purposes, while people kind of describe it as quasi-criminal, you have the same rights. A defendant has the same rights in a criminal contempt that a defendant in a criminal case has, with the exception of the right to a trial by jury. Okay. Now, prosecutors, assistant DAs, they have an obligation to seek justice. Okay. It's not that they're representing the victim of the crime, they're representing the state. They're being paid by the state. And there again, their ethical obligation is to seek justice. And I saw Stan Queller on here a few minutes ago. Stan is a former DA. He can speak to that. But when you are a paid attorney representing a petitioner or a prosecuting party in a criminal contempt, does that not, or let me rephrase it, is that inconsistent with the obligation to seek justice? You're probably going to do what your client wants you to do. You are not representing the state per se, you're representing that individual. So, does that raise a potential constitutional issue? That is what my concern is with the civil contempt. With criminal contempt. Does not apply in a civil contempt, but I'd like to know what Stan's thoughts on that are. Stan,
let's hope he's paying attention.
He is.
I paid attention. Sorry about my voice. We just got back from Nepal late last week, and I caught a little bit of a cold, and so I'm a little hoarse. I understand your concern, Judge. You're right. As a prosecutor, I did not have a client. I had the state as my client. And there were times that I would go to my boss, the DA, if I was concerned about a case and what I might want to do with it. And our deal was that if the DA approved of what I was doing, the victim's thoughts were considered, but ultimately we had the authority to make decisions about whether a case we were going to make a plea offer or go to trial or that sort of thing. That's different if you have a client who is paying you. You may be asking the court to get money back, but generally speaking, you're going to get paid by that client, and you have an ethical obligation to zealously represent them in that litigation. That's what the rules of professional conduct say. Excuse me. Does it pose a constitutional issue? I don't know. There was some discussions in the appellate courts a few years back when we were going through this decision-making process between what is criminal contempt and what is civil contempt. And I know Your Honor probably remembers that.
Yeah, it was the Oakley case, I believe.
Right. Yeah. And so there are some issues about that, but I don't know that it's such a level that it raises a constitutional question. To some extent, it's up to the court to make sure that that lawyer doesn't overstep his or her bounds as a prosecutor. But the flip side of that is, should a litigant who is enforcing a civil court order be burdened with that cost of hiring an attorney, because the state's not going to provide them an attorney. The DA's office isn't going to get involved with these issues. So it's a delicate question. I don't know that there's a right or wrong answer, but there are concerns. Absolutely.
Yeah, and Stan, the constitutional right that I'm referring to is one that we don't really see, but the United States Supreme Court has recognized that a criminal defendant does have the right to be prosecuted by a fair and unbiased prosecutor, that's what I'm talking about. But I struggle with that. I agree 100% with what you said. It is a struggle, and a lot of times we're dealing with child support, and should the enforcing parent, the person that is generally entitled to the child support, be out of more money to, for enforcement of that child support order. And, I struggle with that, but I do have some concerns. I hope that one of these days the appellate courts will address those concerns. But right now the statute is there, and it does not apply to just criminal contempts. It applies to a lot of different things: parenting plans, custody cases, support cases. So, it is a great statute as far as I'm concerned overall. But I do have that issue and that concern in regard to criminal contempts.
Well, and I agree with that. The other concern that I've always had, and when I first started practicing up in East Tennessee, before I went to the DA's office, criminal contempt was not often used to enforce child support. It was the civil contempt where they said, basically, you stay in jail for up to 6 months till you pay your child support. Otherwise, you don't get out of jail. And that was an effective lever, if you will, to get people to come up with some money. I'm surprised more people don't use it. I think that proving the ability to pay is a standard that's harder to reach sometimes, and therefore the criminal contempt statute's almost simpler in the way you look at it from a prosecution standpoint. You just have to prove they didn't pay it.
Well, Stan, let me tell you, you sound horrible, man. Why don't you go get you a little Jack Daniels and honey and try to take care of that. But thank you for sharing your thoughts with me.
Yes, sir. Thank you.
Thank you, Stan.
Anybody else have any thoughts on that statute, particularly the criminal contempt aspect of it?
Paula tries contempts quite a bit. Paula, do you have some thoughts?
Well, I think we call her not listening.
She's not listening.
No. Can't blame her, quite frankly, but
she's not listening. Another question we
I'm
had.
here. I'm sorry. I'm listening. I just don't know how to unmute with I've got a new iPad and I didn't know what to do. I don't, because I prosecute criminal contempt. So I am in favor of attorney's fees because it is so, I agree with Mr. Queller. It is so unfair for a petitioner to have to pay an attorney to prosecute something that the court has ordered them to do. I'm stuck at that point. So I guess I don't really consider the constitutional aspect of that, Your Honor, with all due respect. That's kind of where I am with it. And I did not know that Mr. Queller used to be a DA. So that's very interesting to know.
all right. Any other comments?
Really quick, Mr. John Heacock did put in the chat section, he wanted to get from you again the site for the debt statute, the new.
It's John, it's 36-4-121, and I do not remember the subsection number.
Mm-hmm. Okay. Anybody else want to chime in with questions or comments that you may have about any matters? I have a question that came in advance, and it's asking about trust income and if that is income that could be included in child support cases.
Yeah, I think it can.
Mm-hmm.
I think it, I view it much like a gift under a will. If it's a big lump sum amount that you're going to get, every 10 years, you may want to average it, but I don't understand why it would not be income. As far as the guidelines are concerned. I'm not looking at what the IRS regs say. I'm looking at what the guidelines say, and there's a lot of difference sometimes between the two.
And I'd love to have some dialogue with you on this question, because it does come up from time to time when people are looking at setting incomes for child support. How do you handle if someone gets a lump sum of money that may be like a one-time lump sum, but it's substantial? Maybe it's $100,000 that they got as a, let's say, severance pay, part of a severance pay package, or maybe from a personal injury case, or, I don't know, proceeds from selling a house or something. We know that under the guidelines that is considered income. My question is, how would you factor that into someone's income when we know that it's like a one-time event that happened in 2021 and is not likely to happen going forward?
Actually, I had that come up on a case that did go up on appeal, and I was fortunate to be affirmed by the Court of Appeals on that. This was an inheritance of $100,000, or thereabout, maybe a little less than 100,000. But what I did in that case is I didn't want to attribute $100,000 in 1 year. And the guidelines say that you can average that over a reasonable amount of time. And one thing I looked at is the traditional income that the individual had earned. And he had not made a lot of money, but he made some money. And I decided, I think I averaged it over an 8-year period, and explained why I went with the 8-year period. And I think it's incumbent upon the court to explain what the period is, the length of the period and why they came up with that. But the Court of Appeals did affirm me on it. And I'll be honest, I don't recall why I did the 8 years at this point in time, but I thought it was a good reason at the time. I think that you probably have to look at that on a case-by-case basis. You can't just say, well, I'm going to average it over a period of 5 years. You got to look at it on a case-by-case basis. And again, I think it's incumbent upon the court in their findings to explain how they came up with the length of time.
Mm-hmm. No, I was going to ask you how you came up with the 8 years.
Yeah, I don't remember.
Remember.
And I could be wrong. It may have been 6 years, 7 years, 9 years. I don't.
Well, I do like the fact that you said that you kind of look at what they have historically made, right? So if someone is, let's say, a fairly low income wage earner, you wouldn't want to impute a substantial amount of that income to them. You'd probably want to spread it out a lot more, depending on how much it is, so that it's not too, it doesn't impact them too much at one given time.
You don't want too heavy a tax burden on it.
Mm-hmm.
You want to be fair, and you've got to be fair also to the other side, and make sure that they share in the appropriate amount of that big lump sum. Yeah.
So another question we got in deals with text messages and how to admit them into evidence, because this person in their inquiry said that they find that different courts or different judges kind of have different standards about the use of introducing text messages into evidence. And we know with spoofing, I could on my phone create a text that looks like you sent it to me, because I could create, I could have it show your number sending me this text. So what kinds of things are we seeing with text messages? How do we manage that? How do we deal with that in terms of, proof and introducing it into evidence?
Well, you mentioned spoofing, and you're right. The issue there is the court may have to make a credibility call in order for that to be admitted into evidence. You got one side saying, hey, look, I didn't send that. The other side is, look, this is his or her number. It came from their number. That may involve a credibility call. So you want to be prepared if you're trying to admit it. you want to be prepared to show that it did come from that individual's phone. Well, now, how do you do that? Well, you could subpoena them to bring their phone with them. And remember, if they have deleted those text messages, then they have committed spoliation, which under third rule, I think it's Tennessee Rule of Civil Procedure, I think it's 34B, I think. You know, there can be some pretty heavy sanctions, you know, if they have deleted those text messages. And maybe you can establish the deletion by a forensic expert, you know, a computer forensic expert. So spoofing is always a problem, and then you've got to look at it on a case-by-case basis. Again, credibility is going to be key. Can you show it? Can you show that it's not actually spoofing, that it did come from the other side? If you've got text messages where both sides agree, yeah, I sent that, you know, then it's just, I view it as kind of a statement made by the parties, and it becomes admissible, just like in my mind, just like a phone conversation would, or a verbal conversation between the two, kind of a he said, she said kind of thing. And, you know, depending on the credibility, you know, of the party that is trying to prevent the text messages from being admitted, you may give it great weight, or you may give it very little weight. You have to look at the context of the conversation too. You can't just look at it in isolation, just like you wouldn't look at a phone conversation or a verbal conversation in isolation. And I believe that the rule of completeness applies, and you can require the other side, or you can stand up and read the parts of the text message that may shed light on the message itself. So, you know, I break it down into those two categories. One, if everybody admits these are text messages, fine, let me read it. I may hear some testimony on, you know, context, but the written word is just like the spoken word. It kind of means what it says. If it's spoofing, then it's kind of a whole different ballgame.
Mhm. All right. Well, we've got about 2 minutes left, probably a little less than that. So I want to just see if there's anything anyone else wants to share before we wind up for the evening. Any thoughts anybody wants to share, or questions or anything for the judge before we close out tonight?
I cannot believe Stuart Scott doesn't have a comment on what we have been discussing tonight.
I was
But no
kind of
one's-
thinking that, yeah.
Yeah, no one's Stuart.
I am paying attention whether I'm commenting or not. I was actually going to ask who cut your hair, but I didn't think that would go over really well.
Hey, at least I've got mine, Stuart.
You do. No, I really didn't have a question. I did look it up because I couldn't remember either. And you got it. You were right up on it. 34A.02 is that other spoliation.
Okay.
I thought it was 34. It's 34A.02 because I didn't remember it either. And that's really.
Yeah, I have to look at that.
Oh my God. I keep a book sitting here at my desk because I forget them all the time.
So are you still at work? Or are you at home with your lovely new wife?
Yes, I'm at my home office.
Oh, good.
Who's probably
Stuart recently got married. So Stuart, you're still in your newlywed year, right?
I am till September.
And she is not wised up yet.
She looks at me with stink eye every here and there. I think there are questions like kind of like the clouds in the background of the storm, but they haven't quite arrived yet.
Okay. All right. Okay. Well, anyway, listen, thank you all for joining us tonight. It's been an interesting evening. Next month or whenever we do it again, maybe we'll have some more decision. Maybe we'll have a decision on Roe and some other decisions out of the United States Supreme Court, and we can we can kind of talk about those. And so, but anyway, thanks to everyone for joining in. And I will remind everyone, Friday is a very heavy motion docket. It's going to be very hot outside. So, you may want to call your opponent and try to get things worked out so that you don't have to come to court and get out in that heat.
There you go.
All
Hey,
right.
I think I missed the Cowgirls 2 weeks ago. Did I miss that? Did we have people?
Yes,
You
you
put
did.
something
you
on
did.
Facebook. Wear your cowboy hat, your cowboy
Well,
boots. Did-
yeah, and that came from a comment I made that I did not intend that that was not the way I intended, but people took it to mean that they could wear a cowboy hat and cowboy boots to court, and to blend in with all of the folks in town for CMA. And we had a big crowd that did that. And
I bet that was fun.
yeah, I was just glad they didn't break out into song in the courtroom.
All right. Well, thank you, Judge, and thank you everyone for joining us tonight. Have a great evening.
Thank you all.
Bye-bye.